We will reconvene. I apologize to the witnesses for this delay. And we will begin with Mr. Pitt.
Chairman Frank, members of the committee, I'm pleased to have this opportunity to testify regarding Section 929I of Dodd-Frank and pending legislative proposals that would modify or eliminate it. My views are solely my own and don't represent the views of any client. With the committee's permission, I will only briefly summarize my written testimony.
You may do that with the committee's encouragement, Mr. Pitt. And any documents, statements, or supporting material that any of the witnesses wish to submit will be without objection into the record. Please go ahead.
Thanks. I start with the belief that there is and should be a strong presumption in favor of ensuring the accountability and transparency of government agencies and their decision-making. But Section 929I, particularly as it has been interpreted, does not vitiate SEC transparency or accountability. Rather, I believe it was intended as a necessary tool to permit the SEC to be as effective and efficient as it can be in performing not only its existing functions, but the myriad of new functions that have been assigned to it under Dodd-Frank. The Commission gathers a wide range of proprietary and confidential information from those it directly regulates. To perform effectively, it has to obtain information rapidly with a minimum of effort and contest. Section 929I was intended to permit the Commission to do that, as bank regulators have done for decades. Persons who are fearful of improper disclosure of their proprietary or confidential information work assiduously to limit or condition the SEC's prompt receipt of information, as well as condition the terms on which the SEC receives it. I know this because I used to represent such persons when I was practicing law. Once the SEC obtains information, corporate competitors and predators try to wrest that information from the SEC to use against those who have entrusted their sensitive data to the agency. Section 929I enables but does not compel the SEC to prevent those kinds of injustices from occurring. To the extent that there are concerns about its breadth, the SEC's guidance yesterday should allay those concerns. There are two principal ways in which proprietary data may be sought from the SEC, either through the FOIA or through non-FOIA means, such as litigation subpoenas or discovery demands. 929 clarifies the reach of two existing FOIA exemptions, and it's critical, given the new classes of entities the SEC is charged with regulating and overseeing. With respect to non-FOIA demands, the SEC is given an equivalent of the bank examiner's privilege that bank examiners have long enjoyed. I believe that the provision clearly prohibits the Commission from withholding information from Congress, as it should, and it would not shield, particularly as interpreted, materials necessary to determine how the SEC is doing its job. It enables the Commission to preserve confidentiality of private sector companies' sensitive data if making that data public would inflict unfair harm. The SEC's issuance yesterday of guidance, in my view, is an example of government operating at its best. The guidance is binding on the Commission and its staff and makes perfectly clear that the new provision will be administered intelligently and fairly and not as some automatic barrier to disclosure. The committee's invitation asked for responses to a number of questions, and the only one that I would just single out here is that the current bills that are pending, which attempt to either repeal 929I or otherwise limit the SEC's abilities, I think raise some problems. What we really need, if there is going to be an adjustment, is a carefully constructed approach that is comparable to the SEC's guidance. And I believe that as interpreted by the SEC, 929I will be only a useful but not an abused tool in the SEC's arsenal to obtain necessary data. Thank you.
Next, Angela Canterbury, who's Director of Public Policy at the Project on Government Oversight.
Chairman Frank, Ranking Member Baucus, and members of the committee, thank you for inviting me to testify today and for your willingness to revisit this issue. I am the Director of Public Policy at the Project on Government Oversight. POGO has a keen interest in ensuring the public can hold our financial regulators accountable for protecting the interests of taxpayers, investors, and consumers. This is why we are deeply concerned about Section 929I of the Wall Street Reform and Consumer Protection Act. Section 929I would provide the Securities and Exchange Commission with an unnecessary and overly broad exemption to the Freedom of Information Act and a blanket authority to withhold records. It strips protections of due process currently in place and gives the Commission an accountability shield that is not in the public interest. Indeed, limiting disclosure of public information should not be done lightly, and the burden should be on the SEC to show very compelling and specific need. With all due respect to Chairman Schapiro, they have not yet done so. Although we fully understand the need to protect against disclosure of certain confidential information collected by regulators, pre-existing FOIA exemptions are more than adequate. In fact, the concerns raised by registered entities and the SEC seem very inconsistent with reality. The courts have strongly censured the SEC for non-disclosure, and last year an audit conducted by the SEC's Office of Inspector General determined that the SEC practices create a presumption of withholding in spite of the President's mandate for the presumption in favor of disclosure. The OIG also found that the agency's FOIA release rate was significantly lower compared to all other agencies. But today, Schapiro said it all when she said, "We have a bias toward turning over anything we can." Notably, today she could not come up with one instance in which confidential business information collected by the SEC has been revealed to the public through FOIA or litigation. The public stakes in more, not less, transparency and accountability at the SEC cannot be overstated. American families continue to suffer from the financial crisis created in part by systematic regulatory failures. The SEC claims to need 929I so that it can more effectively obtain records to police Wall Street, but the SEC's failures, most notably its botched investigations of the Madoff and Stanford Ponzi schemes, had to do with enforcement, not its inability to collect records. On the other hand, if the serious problems with the agency's operations exposed by these and other scandals are kept hidden from the public, as 929I allows, the SEC will not be held accountable. In one recent case, former SEC enforcement attorney Gary Aguirre was able to use FOIA to prove the agency had retaliated against him and bungled its investigation of insider trading at Pequot Capital Management. He eventually used these records to force the SEC to reopen the case, leading to a $28 million sanction and vindication for Aguirre's wrongful termination. We understand that the Commission's job is made more difficult when registered entities refuse to cooperate, but we're not convinced that the agency is uniquely burdened, nor is it lacking in the power of subpoena or the ability to levy penalties. We do not believe it is necessary to expand Exemption 8 either, but if Congress shares the Commission's concern that certain newly regulated entities may not be considered financial institutions, then it might be appropriate for Congress to make that clarification. In any case, because it is already aggressively applied, Congress should examine Exemption 8 and supply clear standards for employing it. Also, we do not believe that it is in the public interest or in the service of the Commission's core mission to give the agency extraordinary authority to refuse subpoenas from civil litigants, as the SEC guidance does. Why should defrauded investors, whistleblowers who suffered retaliation, the media seeking to uncover corruption, or any other party be denied access to public documents that might make the difference in exposing corporate malfeasance or holding the agency accountable? Again, the SEC has not demonstrated a real need. In fact, it already is very difficult for a civil litigant to enforce a subpoena on a federal agency. The SEC has many tools at its disposal for quashing subpoenas and can already warn registered entities if confidential information might be disclosed in a subpoena. The decision about whether or not a subpoena should be enforced should be made by the courts on a case-by-case basis, as is the norm, not by the SEC. For this reason, we do not support the SEC's guidance in this area. In any case, we do not believe that agency guidance is sufficient to allay concerns of the public interest, since it can be changed with no public notice, oversight, nor is the agency discretion appropriate for Exemption 3 or subpoena refusal, particularly this agency's discretion. So we are pleased there is some agreement to codify the changes to 929I, but the solution is to re-ring the bell, as Representative Issa said today, not codify the agency's guidance, which is another accountability shield. We urge you to pass H.R. 6086, H.R. 5924, or similar legislation to repeal this blanket secrecy provision, and I invite you to review our other recommendations calling for additional examination of Exemption 8 and follow-up of the audits by the OIG. I thank you very much.
Rick Blum, who's the coordinator of the Sunshine and Government Initiative.
Mr. Chairman, thank you for the opportunity to testify today. I especially want to thank you for holding this hearing. I testified today on behalf of the Sunshine and Government Initiative, a coalition of media associations promoting transparency in the federal government. We'd like to emphasize 4 points. First, the statute as written is broad, too broad. I think we've heard that today. Second, only an act of Congress can fix this problem. Third, the approaches pending before Congress to fix 929I would be better than no action at all. And fourth, Congress should strengthen the disclosure and review of proposed statutory exemptions to FOIA. As you have already heard under 929I, the Commission could exempt from a disclosure any information about official business, including its approach to oversight and supervisory information having nothing to do with trade secrets. Simply put, the statute gives too much discretion to the SEC to decide what should be disclosed or withheld, a key factor the courts look at in FOIA Exemption 3 cases. Even with 929I, the sought-after cooperation from private entities may continue to be elusive. For example, one influential firm reacted to Dodd-Frank by telling firms to stamp confidential on documents they used to freely turn over to the SEC. For these and other reasons, I identify in my written testimony, and we believe 929I is overbroad and Congress should take action. Second, only an act of Congress can remedy 929I's flaws. Even the most disclosure-friendly guidance is no substitute for congressional action. We've seen agencies interpret statutory exemptions to FOIA as broadly as they see fit once they have the discretion. The lesson's clear. Over time, when Congress writes broad exemptions, the government broadly uses them. Turning to solutions, either repealing 929I or expressly applying Exemption 8 to FOIA to the SEC and the firms it oversees would improve the status quo. It's important to provide clarity, not breadth. Exemption 8 has its own flaws. Chiefly, it's broad as well. But this approach avoids enacting broad ad hoc exemptions like 929I. On the issue of third-party subpoenas, the SEC's position could significantly hinder open judicial proceedings, and the issue deserves closer scrutiny. These issues should not be taken up lightly, but publicly, deliberately, and separately from the FOIA discussion. I want to use my remaining time to note one reason this hearing is being held today. This controversy arose because the process that Congress uses for proposing statutory exemptions to FOIA is flawed, leading repeatedly to imprecise or overbroad or redundant legislation. This committee fell victim, in a sense, to this weakness. In the meantime, by our count, federal agencies have used over 250 federal laws over the last decade to deny FOIA requests. That's in addition to FOIA's categories that exempt from disclosure things like trade secrets or classified information. 929I is just one of these secrecy statutes. Sometimes the purpose of these exemptions is understandable. Other times it is not. Why protect the identities of honeybee handlers or watermelon growers? Congress can take modest, feasible steps to strengthen how these proposals are considered, such as enforcing the Open FOIA Act of 2009, which requires all proposals to cite FOIA's Section B3, promoting disclosure in searchable form at the time these proposals are introduced, routinely referring Exemption 3 proposals to the Oversight and Government Reform Committee, which is oversight of FOIA, as we know, for brief review, or assuring new Exemption 3 statutes are necessary and existing exemptions are inadequate. These feasible steps can avoid needless litigation and congressional controversy while reinforcing our democracy's promise that the public should know what the government is up to. To conclude, Mr. Chairman, journalists tell us they are chiefly concerned that the language in 929I is too broad, and only an act of Congress will fix this problem. We look forward to working with this committee to improve both this provision and the way Congress handles such secrecy provisions in the future. And we appreciate this opportunity and look forward to your questions. Thank you.
Stephen Mintz.
Good afternoon, Chairman Frank, Ranking Member, and members of the committee. My name is Stephen Mintz, and I'm the founding partner of Mintz & Gold. Thank you for inviting me to testify on this important issue. During the past few years, I have served as lead counsel in a number of Freedom of Information Act lawsuits against the Federal Reserve, the Department of Treasury, and the Securities and Exchange Commission, and have been successful in forcing the Treasury to produce documents related to the AIG and Citigroup bailout, and to force the SEC to produce documents related to the failed investigations of Bernard Madoff and R. Allen Stanford. Section 929I of the Dodd-Frank Act has the unintended consequence of weakening government transparency. Section 929I gives the SEC unreviewable control over the information it has to share with the public and is directly contrary to the transparency goal of the Dodd-Frank Act. FOIA was enacted in 1966 with the notion that a democracy requires accountability and accountability requires transparency. A central feature of FOIA is the role of courts in mediating disclosure disputes between citizens and the executive branch. Section 929I gives the SEC the power to refuse disclosure of any document or record as long as it can say that it was obtained through or even based on or derived from the exercise of the agency's surveillance, risk assessment, or other regulatory and oversight activities. This broad language, combined with Exemption 3B, completely eliminates the role of courts as the arbiter of disputes under FOIA. While Chairman Schapiro has taken the position that the new FOIA exemption is required to protect proprietary information and trade secrets of business emitters, this type of information has always been protected by Exemption 4. Any legitimate concerns that regulated firms have about their proprietary data are satisfied by Exemption 4 and SEC Rule 83, which provides a specific procedure for an entity submitting information to request confidential treatment and to be heard if a FOIA request affecting the information is made. The same is true for proprietary information sought through subpoenas. And frankly, the guidelines that have been proposed by the chairman now simply want to substitute out the role of courts to be the final decision maker and to substitute in the SEC as the ultimate decision maker on whether information should be released or not. That changes and reverses the role. The suggestion that the SEC needs a new FOIA exemption to compel regulatory compliance is troubling. With subpoena power and sanctions that are available, the SEC can force registered entities to produce information. And if that remains a problem, the solution should not be to entice those entities with promises of secrecy, but rather to adopt additional regulations to ensure that they will comply with SEC requests for information. Section 929I is also unnecessary to prevent interference with the SEC's law enforcement functions, since materials compiled for law enforcement purposes are already protected by Exemption 7A. By the same token, privileged documents are covered by Exemption 5, and records implicating personal privacy interests are covered by Exemption 6. In addition, the SEC also uses Exemption 8, improperly in my own view, to block FOIA requests. Section 929I provides the agency with a get-out-of-jail-free card, enabling it to invoke Exemption 3 without actually conducting a document-by-document review. Instead, the agency can bypass FOIA by simply labeling the requested documents as material obtained pursuant to its regulatory authority. The SEC has not pointed to a single instance in which it has been denied the use of an existing FOIA exemption because of statutory language that is overly narrow. Both my own experience with the SEC and the findings contained in the report of the Inspector General suggest that the SEC is struggling with FOIA compliance not because of inadequacy of existing exemptions, but because it does not have the resources it needs to collect and review materials as FOIA requires. I respectfully submit that an evisceration of FOIA through 929I is neither necessary nor appropriate. The SEC should not receive an agency pass from the Freedom of Information Act. Accordingly, Section 929I needs to be repealed in its entirety. The recommendation by Representative Issa, I agree with that. Let's repeal it, and then if they need one, it can be done properly. Thank you again for giving me this opportunity to testify, and I look forward to answering any questions that you may have.
Ms. Susan Merrill.
Chairman Frank, Ranking Member Baucus, and members of the committee, I'm Susan Merrill, a partner in the broker-dealer group of the law firm of Bingham McCutchen. Prior to joining Bingham, I served as the Chief of Enforcement at FINRA, the Financial Industry Regulatory Authority, and prior to 2007, I served as the Chief of Enforcement at the New York Stock Exchange. Thank you for the opportunity to testify today. I appear on behalf of SIFMA, the Securities Industry and Financial Markets Association, to provide an overview of the securities industry's position with respect to Section 929I of the newly enacted Dodd-Frank Wall Street Reform and Consumer Protection Act. The securities industry has a strong interest in maintaining an open, cooperative, and efficient dialogue with the Securities and Exchange Commission in the course of SEC exams. Registered entities being examined understand that it is in no one's interest to hinder the Commission's ability to comprehensively complete its work. However, the industry's practical ability to produce certain types of sensitive, proprietary, or confidential information to the SEC was, prior to the Dodd-Frank Act, significantly impeded by federal laws governing the Commission's legal obligation to publicly disclose such information in certain circumstances, whether the SEC supported such disclosures or not. Section 929I directly addresses these issues. We believe the practical effect of this provision will lead to greater trust, openness, and efficiency between regulators and the industry, and ultimately to better protection for investors and stronger markets. It's for these reasons that we support the new law and oppose the efforts to remove it from the Wall Street Reform and Consumer Protection Act. One logical question in response to the industry's concerns is, wouldn't the type of information that firms fear disclosing be protected under the FOIA exemptions? The answer is not necessarily. The FOIA exemptions are simply too imprecise to allay the industry's fears regarding public disclosure. And the issue runs deeper than mere semantics, because it is this lack of clarity that impedes the flow of necessary information between firms and the SEC staff. And similarly, it is the clarity provided by Section 929I that will foster open communications between the firms and the SEC. But FOIA is not the only source of concern prior to the Dodd-Frank Act. Additional federal laws obligate the Commission to disclose documents in its possession in response to third-party subpoenas. Information so produced generally enters the public domain upon production by the SEC. The FOIA exemptions for trade secrets, confidential communication, and exam reports simply do not apply here. The Commission is left to the uncertainties of the common law and to general litigation and discovery processes in seeking to protect from disclosure the most sensitive information it receives from regulated entities in the course of its exams. The fact that the FOIA exemptions do not apply to third-party subpoenas served upon the SEC is, in the industry's view, the most important consideration in weighing the interests served by Section 929I. Since 929I squarely addresses this issue, its provisions will function to foster a more open and cooperative dialogue between the securities industry and its regulators. With no risk of compelled disclosure looming over the production of information, regulated entities are now able to produce all that people would likely agree the Commission should have access to, without fear that the Commission will later be legally obligated to disclose it. Section 929I effectively closes the third-party subpoena loophole that provides a path to compelled public disclosure of confidential information, even when the FOIA exemptions are met. There's a sound logic in Congress's recognition of the fact that there are certain types of sensitive information that one would not expect a financial institution to disclose to the public, but which one would expect them to freely disclose to its regulator. Section 929I achieves this balance, and I urge the committee to leave it intact.
Thank you. A couple things are very clear. There's going to be legislation. The guidance alone, obviously, even if people thought it was perfect, doesn't suffice because it can be undone. So it has to be statutory. Ms. Blum, I did have some question about the procedures. And I think you may be looking for procedural solutions that nothing is going to be a substitute for people reading. This particular issue has been in the public domain since 2008. It's passed the House unanimously. As far as referring it to the Committee on Government Reform, leaders of the Committee on Government Reform were members of the House Senate Conference Committee on this. They had a month to look at it. Frankly, I think people looking at it in the abstract didn't fully understand it until the lawsuit. And so I'm not sure that anything would suffice. And that's not something that can be cured. Sometimes you don't understand what something means until, in fact, it gets put into effect. So I understand the procedural things, but procedurally, this one couldn't have been purer, and it just took the lawsuit.
Can I address that point?
Yes.
Things may slip through under the procedures that we think would improve the situation. And you might not find out that there's a concern.
Well, excuse me, I would take exception to slip through. Nothing slipped through here. It was public, it was vetted, it was...
I appreciate that very much. I appreciate that very much. But we see this happen, very often. Where
what exactly is your procedural solution to this?
We think that there's been inadequate reviews of
but
statutory exemptions to FOIA.
How do you... But what's your procedural... Again, it's been out there in public. What's the procedural way to force a review?
I think having a referral to the Committee on Oversight and Government Reform in the House would help, and just do it routinely.
I would note that this was before them for a month, and it didn't... I'm not sure, as I said, they saw it. Nobody understood the implications of it until the parties in the lawsuit brought it to their attention.
I think that when agencies propose these, they ought to go to the stakeholders. I don't know how many reporters saw this before this was, introduced, and there was a lawsuit. And frankly,
well,
part of my job is to look for these things. And
well, I have to say some responsibility. I thought went on the media to cover the agencies that they're covering. There was never anything secret about that. It was sent up in public letters. We discussed it in hearings.
Sure.
I'm not sure how much we can spoon feed the media. Nobody ever got in the way of the media covering this agency or this committee or this Congress from looking at it.
We're not asking for to be spoon-fed. I think what we're asking is to have a fair hearing and adequate review for the impact on FOIA and transparency.
There's been we've had hearings on this, and nobody noticed it until the lawsuit. So
I think that the language actually evolved from the time frame that you're talking about. I think some of the earlier versions were probably slightly narrower. Some of the real broad language didn't come in until later.
The same.
But you're right. I wish we had seen it
earlier.
I'm
sorry, the language that was in the final bill was there for over a month. It was in public, and in fact, it was in both bills adopted in the House and Senate. So it didn't evolve. Let me just ask one other question. What you have is this, and the one concern I think is on the third-party litigation. Congress passed, it was controversial, over the veto of Bill Clinton, a limitation on the ability of plaintiffs to get discovery in corporate litigation. One question raised is this a way around that? Now, that was actually passed by Congress. I think it was the only bill passed over Bill Clinton's veto. And to get discovery in a private securities lawsuit, you need to meet a certain standard. Does this become a way around that? That's just the question that occurred to some of us as we were listening. Namely, if the SEC has subpoenaed, has gotten information for regulatory purposes, and you're in a lawsuit, and you might not be able to meet the standard of the Securities Litigation Act, is this a way for you to get discovery without meeting that standard? And if so, is that something to be concerned about? Any of the panelists?
The answer, I think, Mr. Chairman, is yes. Without 929I or something like it, litigants who have very different objectives would be able to get around some of the barriers on discovery. It doesn't mean that the precise wording of 929I is ideal, but it does mean that there's both a FOIA and a non-FOIA component, and both have to be addressed.
Yeah, let me go down the list on this. Is that any kind of a concern that it should anything that the SEC gets for its purposes, and I think there's some consensus here about the SEC not having it, but should anything the SEC gets from a private company be fully available to any litigant who has an issue with that company, who might not, in the absence of the SEC getting it, otherwise be able to get at it? Mr. Canterbury?
No, sir, I don't believe in every case, but I think our concern is for the whistleblower that comes to the Securities and Exchange Commission.
Okay,
in the
let me stop you, please. Fine, because that's what we have the advantage of in legislating. And that's a distinction we could make in legislation. We could protect whistleblowers, but purely private disputants in a commercial dispute could be treated differently. I appreciate that distinction, and that would be very much the kind of thing that we could look at.
Defrauded investors who cannot go to the Bernie Madoffs but have to go to the SEC to prove harm. We're also concerned that the SEC is empowering itself to make a determination that should be made by the courts. I don't know of any other agency that has
well, let me ask you this
discretion.
then. Let me ask this. If we were to leave it as is, when a court was deciding whether or not to, well, let me ask you this, because I don't know the law here, there are lawyers here who will. I'm a private company whose material has been taken by the SEC. Some litigant against me in a purely private dispute, not a whistleblower, seeks to get that information and subpoenas it from the SEC. Who has the ability to defend against the subpoena? Do I have a right to intervene and defend against the subpoena? Would I, Ms. Mintz?
Well,
yes?
they do.
If you're given notice.
Yeah.
What's that?
If you receive timely notice, which is up to the
all right, Ms. Merrill, okay, yes, Mr. Mintz?
Yeah, the industry's concern is that the SEC oftentimes doesn't follow their own procedures and provide them with notice. But once they provide that confidential information, whether there is a FOIA request or a third-party request.
I'm sorry, but let's not have either. I tend to ask very specific questions. I would appreciate very specific answers. Sure. All right. So now the answer is apparently, and please don't assume that I know more than I know. The answer is that if I have gotten notice from the SEC that someone in a subpoena is seeking my private information, I have the right to go to court to defend against the subpoena?
I can appear in federal court, make a motion to protect my
the answer
proprietary...
would be, yes would handle
Absolutely.
that. Yes would handle that, Mr.
Yes.
But you're telling me that the problem is that the SEC may have been lax in giving the requirement.
Well, that's
the notice.
That's what the industry is telling me as we sit here today.
No, I think
yes,
that the issue is that if you receive timely notice that your documents have been subject to such a subpoena, then you do have the opportunity.
All right. Well, then again, these things get complicated. That's why one thing you could do would be to say that that subpoena wouldn't be valid couldn't be enforced until you got notice and time to respond. That would take care of that. So you do have the ability. Now, the question that I have for everybody is this. Again, these are questions I don't know the answer to. If I am given notice and have a chance to go in and defend, is the standard that I use to prevent them from getting this the same as in the Securities Litigation Act, or would there be a lower standard? Mr. Mintz?
I can't speak specifically to the Securities Litigation Act, but I can tell you that if a third party is seeking to protect its own proprietary information, it's going to be a common law privilege. And if it's...
All right, well, but we went beyond that. We did excuse me. But the reason a statute was passed over Bill Clinton's veto, it was taken very seriously, which raised the level of the predicate you need before you can get into this. And it would seem to me we would be undermining that if people like that. Some people didn't like it. Bill Clinton vetoed it. Some people thought it was a terrible idea. I do not think it has had the negative consequences others have said, but there it is. let me put it this way, would there be an objection if we did this to saying that in those cases where we are dealing with third-party commercial litigation, the standard for enforcing a subpoena would be the same as the Securities Litigation Act? And if you're not familiar with it off the top of your head, if you would get back to us. That's, I mean, again, Frank, it's easy to say yes, no, but that's how we get into trouble, and that's why we need to do this. To me, that is the one, frankly, sticking point, I think, which is, we don't want, since I keep talking about all my legal ignorance, I show my legal knowledge with a little Latin here, sub silentio, amend the Securities Litigation Act. So if all of you would address that issue, the question would be, and I think this would go to meet some of the concerns that third parties, that people had. If your proprietary information given to the SEC for its purposes was the subject of a subpoena by a litigant against you, do we resolve this in part by saying, okay, first of all, the subpoena can't be enforced until you have been given notice by the SEC, and secondly, the standard which you can use to defend is the same as the one we set in the Securities Litigation Act, that there has to be that. Yes, Ms. Merrill.
If I may, I don't think that simply allowing the entity that's being regulated by the SEC, a securities industry registrant, to go to court and defend at all addresses the problem and the reason that the SEC sought this legislation to begin with. And I'll give you an example. This legislation is trying to allow the SEC to take what it gets while it's in an exam mode and protect it from anyone having to, 3 years down the line, go into court and make those arguments. And here's why. If you're sitting with an examiner and the examiner says, please show us everything we need to understand how you trade and hedge your global book across 5 entities in 5 different jurisdictions, which is what many global firms do. They pass the book as it trades, and as one market closes, then it trades in Tokyo, and then the sun comes up somewhere else, and they trade it to another foreign affiliate. And the entity, the securities entity that's regulated in the U.S., says, I would show you all of this in order for you to understand our entire global strategy so that you can make a decision about the systemic risk that you're looking into. But I would rather not, because I don't know if what I'm going to show you is going to end up being protected 2 years, 3 years down the line when some magistrate or judge decides whether or not they think it should be protected. And so they simply will say, I'd rather not show you that. And that's an example where the SEC's enforcement proceedings and powers do not reach.
If that were true of them, we might empower the SEC to do more. What I'm suggesting is that we tell that entity, but here's the standard, that is, at any point, no one, and this is why I'm suggesting that might mediate that conflict, no one would be able to get that information unless they could independently have gotten it under the bar set by the Securities Litigation Act, that they could show that there was some basis for this, that it couldn't be purely a fishing expedition. So, Mr. Mintz?
Well, the only point I would add is if the final decision is being made by a court as opposed to the agency itself, then I think we have something that's workable.
Then the question is, what's the standard by which the court does it? And I do think there is a problem. And we could carve out whistleblowers. We've done this. I think we had some good whistleblower stuff in the bill in general, and we were very sympathetic to that. But that's the one area, and I'm hoping that we do something about this by the end of next week. Yes.
Well, I'm just concerned that there's not really a problem here to fix. We have not seen one example of proprietary information provided in this setting. So is there really a problem?
Well, maybe not, but I don't know that we should not try to anticipate one. If what we're talking about doesn't do any harm, I don't understand why we wouldn't try to do it. We don't always want to be reactive.
I think that I can...
What the SEC, I take it back. What the SEC tells us the harm is this. Not that proprietary information has been so much released, but that they have had a greater degree of resistance to doing it. Yes, Ms. Merrill?
That's what I was going to say. I think that the issue is that there is not now a free and open relationship between the regulated and the regulator. And if you want that to grow so that the SEC in its exam provisions can actually understand what these firms are doing and do what it needs to do to regulate the systemic risk in the system, then you have to give them the tools
Ms. Merrill, here I
to
think
let
you
them
may-
have that relationship.
I'm sympathetic to the issue, but I think you're over-arguing it. The notion that we will reach a point where there will be that harmonious relationship between the regulator and the regulated. I am called to mind Woody Allen's paraphrase of the old hope. The lion may lay down with the lamb, but the lamb won't get much sleep. I
but
think
there is a
the
difference.
likelihood of reaching. I mean, I can see where you might diminish the resistance, but an open, cooperative. Look, let's be clear too. We're not talking about the average company. The SEC doesn't, I hope, randomly go out and decide to get all this information. They're generally doing that where there's some reason to think that something wasn't so hot. So the notion
not
that
true in
those
the
companies
exam
are going to
context.
Mr. Chairman.
I'm sorry, I didn't finish yet. I think you've given me an idealized view. Let me put it this way. The notion that we're going to have this wonderful voluntary cooperation between the regulator and the regulated is not, I think, the model that we want to legislate to. Yes, Mr. Pitt.
Let me first say there are examples, many of which can't be identified publicly, but there are examples where proprietary data has not only been sought but received. But the specific problem really...
Yeah, but sought by a private party.
By a private party, yes. After the Madoff problem, one of the things that's happened now in SEC investigations is that these investigations now take months and months and months. And because the staff is concerned about missing anything, which they should be, they now demand far more paper and far more documentation than is necessary for the traditional kind of examination. I'm not saying that's improper. I'm just saying this is now a fact of life. We work with a lot of entities that produce volumes and volumes of material that the SEC usually doesn't need. But once the SEC has it, it doesn't want to give that information up, and there are sound policy reasons why it shouldn't. And I believe that this committee, if it is going to adjust this provision, should look at who is making the request and what the purpose is. People have mentioned whistleblowers. I don't see that as being a proper subject of 929I. But I do believe that if it's one private competitor trying to take advantage of another competitor's investigation or examination by the SEC, then there ought to be clear and unequivocal
That's the area,
protection.
and I think, I'm trying to get something done here. Let me ask this conceptually, and I would, I guess, Ms. Canterbury, Ms. Blum, Mr. Mintz, is anyone arguing that anything the SEC gets ought to be available to a private party simply because the SEC had it? Does anybody advance that argument?
No.
Okay. So then the question, and I appreciate that, and I didn't think so, but it's good. So then the question is, it doesn't mean that that's the problem with a simple repeal. The question is, what could we put in there? What are the legitimate barriers that ought to be exerted if we all agree that not everything the SEC gets should go to everybody else? I think whistleblowers will be exempted, but they get the freest ride. The next cut for me is the Congress has already litigated. People don't like it, the Securities Litigation Act, which set this barrier. And that would be one conceivable way to look at it, which is to say that a private party has to meet the same requirements, a litigant, a competitive litigant. And you could separate out shareholders. I mean, there are different categories. There are whistleblowers, there are shareholders, and legitimate shareholders, and competitors. I don't expect to get all those resolved now. I would invite any of you. We got about a week to think about it. This helps me. This makes progress as we conceptualize it. I just say to people, there's going to be legislation. The Senate's moving, and there's a great deal of public demand. So there's going to be legislation. And I think there's consensus in a number of areas. The SEC has already, conceded it should not be itself able to defend. That'll be that'll be clear, and they've already, as you know, Mr. Mintz, waived any notion of invoking it in the lawsuit that you're doing. Whistleblowers. But then when we get to other categories, there is a question about what different level should you have to meet if you're a private litigant to get information the SEC got, and by what category? And anybody who has any suggestions on that, we'd be glad to listen. Is there any further any witnesses want to say?
I think at a minimum, you would want to extend the FOIA exemptions to the private litigation field so that third-party litigants would not be able to get information that is protected if it were asked for under a FOIA request.
I believe that there are currently standards for weighing privilege that are very different from FOIA, and it involves a judge gauging the public interest, versus the private interest, and that's a completely different ballgame.
I would invite both of you to submit further conversation. Again, there need to be some limits, but I would say, Mr. Merrill, when you're arguing in court, you got to go, well, FOIA or this or that. We can, mix and match and take one from column A and one from column B. So, yes, I think everybody would agree there got to be some standards that differentiate. Let's put it this way. I think there's consensus. There is information we want the SEC to be able to get fairly freely, although we want to diminish resistance to the SEC reaching broadly for information by giving some degree of protection to for proprietary information, absent some showing of wrongdoing, et cetera, or some other thing. That's and if you will help us with that, I think we may be able to greatly advance this.
Would it be useful if we submitted something?
Yes, it would be. And Mr. Blum, if you leave us your phone number, we'll call you every time we got an amendment.
We're not looking for special treatment.
Well, I'm sorry. I thought you were when you said notify the stakeholders. If you talk about notifying the stakeholders, that's special treatment for the stakeholders, as opposed to simply making it public.
I would hope that by the end of next week there would be clear differentiation between dealing with the third-party issue separately from the FOIA issue, and that in that process there's some way to draw that clear line.
I thought that's what I was talking about, yes.
Well, but I think the 929I puts the two together, and I think that there's got to be some clear, bright line.
Well, we're
that
going to amend it.
immunizes-
I understand that. We're going to amend it. We're going to change it. We're going to change
Okay,
the law.
but I hope that there's some way, clear line to immunize whatever comes out of this from allowing the SEC to avoid embarrassment.
Mr. Blum, I can ask you.
So when there's competing interests.
Have you not been here for the last few minutes?
I have.
I'm offended by that question because it's so clearly, I'm sorry, please listen and I'll listen to you.
Okay.
It is so clearly contrary to the subject of the conversation we've been trying to have. It is tendentious for a reason I don't understand. First of all, we've been making very clear the SEC itself will not be involved, that they won't be able to use it. We're talking solely about protecting third-party proprietary information. I thought we were clear. I'm frankly disappointed, I should say, by the tone of the question. No, go ahead.
Well, let me refrain. You have been a clear champion of transparency by having the open committee process and by doing many things to make this a more open process, and we appreciate that very much. At the same time, I just want it to be clear that by way of example, if the SEC is investigating something or cooperating, and writes a supervisory letter, a year later, if no action has been taken, say the SEC doesn't like the formula that a credit rating agency uses, and suggests changes, will the public see that supervisory letter? So it's not a third-party.
Mr. Blum, nothing in what we have been talking about suggests that would be protected. Is a supervisory letter like that third-party proprietary information? We are talking about.
I agree that there's a
excuse me, Mr. Blum. I'm listening after I've made this clear, but we have been very clear that we are talking solely about proprietary information from a registrant which the SEC gets. How could you possibly confuse that with a supervisory letter? And I'll be glad to listen.
The point is well taken.
I thank you. And yes, I do invite, you can write this. By the way, some of you might be more inclined to write statutory language. Some can do it, conceptually in English or whatever. But I'm serious. I don't expect everybody to read everything. I think we've got a great deal of agreement. And I say this, by the way, it's in everybody's interest because, if there was any significant controversy, our chances of getting this done by the end of this month diminish. And, it still has to go to a president who will be listening to the SEC. So if you will can help us along these lines of dealing with protecting the whistleblower function. I mean, the SEC is completely unprotected. The whistleblower is completely protected, and third-party proprietary information somewhere along that spectrum. That's where we want to go. I thank the witnesses. This has been very useful for me.
Thank you.
Thank you.
I think so. He was mixing apples and oranges, I think. That's why I wasn't anticipating it, and I wasn't sure either